Hello, everybody, and welcome to the first of the Cornerstone Climate Month webinars for 2025. We'll just give it a moment for people to file in from the waiting room because I can see the attendees going up on screen. So we'll just give it a moment as people join us. But it's really great to be kicking off Cornerstone Climate Month with this, well, I see on the screen it says a deep dive into the latest developments in UK climate litigation, covering the major cases shaping future regulatory and judicial dynamics. Well, that's a bit of a mouthful, but we will be covering climate litigation in the UK today. My name is Lois Lane. I'm a planning and environmental and public law barrister here at Cornerstone, and I'm joined by two fabulous colleagues, Rowan Clapp and Max Millington, and we're going to do a whistle-stop tour through some of the outline framework for climate change litigation in the UK, some of the key cases from the last year, and then looking ahead to the future. So if we could just flick on to the next slide, which I think repeats some of what I've just said and talks about what we're covering. So yes, we'll start with an overview of the legislative and policy context, and I'll hand over in just a moment to Max Millington, who'll be looking at that. Then Rowan Clapp's going to tell us about what key cases have happened in the last year or two, and really looking at the focus that UK climate litigation has had on the planning system and planning challenges. And finally, I will get the fun job after they've done all the hard work of looking ahead and speculating as to what the next few years might bring. So please do put your questions in the Q&A. We'll be using the Q&A function for that rather than the chat. We'll try to answer as many of them as we can going along. We hope to be able to leave some time at the end for questions, but we'll see how we go for time. And there'll be an email address at the end if you've got any burning questions that we don't get around to answering today. So please do put your questions in the chat. But without further ado, I'm going to hand over to Max to take us through the overall legislative and policy context.
Thank you, Lois. Good afternoon, everyone. Yes, as Lois says, I want to look at the context briefly in this first section of the webinar to look at what has been the backdrop really for some of the climate litigation in the UK over recent years. Now, I appreciate that at least part of this framework will be very familiar indeed to some of you, but perhaps less so to others. And I'm hoping that it will provide a helpful grounding for understanding and thinking about what is to follow from Rowan and Lois this afternoon. So to start with, Will, if you could move to the next slide, thank you. To start is just to acknowledge that many nations of the world, including the UK, have recognised the existential threat posed by climate change, and that through the Paris Agreement have made a commitment on the international stage to pursue efforts to address this threat. And there's just a quotation from the Supreme Court in Finch recognising this fact. So Will, if you can skip forward, please, thank you. So the primary means through which that commitment is reflected and given effect in UK law is the Climate Change Act 2008. Now, Section 1 of that Act contains the government's statutory duty to ensure that the UK's net carbon account for 2050 is at least 100% lower than the 1990 baseline, and that is what is referred to by net zero. Now, the way that this is intended to be achieved through the legislative scheme is that sections 4 and 9 of the Act impose the duty to set carbon budgets for each succeeding 5-year period, taking into account advice from the Specialist Climate Change Committee. Now, what those carbon budgets are is, as they are legally binding caps on the maximum level of emissions for the relevant 5-year period. So effectively, that is the amount of carbon that the UK can spend within that time frame, hence the phrase budget. And the aim of this scheme is to gradually reduce the budgets over time, working towards that net zero target in 2050. Now, so far, there have been 6 carbon budgets laid before Parliament, covering the period of 2008 to 2037, and the 7th is due to be laid before Parliament in 2026. Will, so if you can skip forward, please. Now, the most recent advice from the Climate Change Committee published in February 2025 recommends an 87% reduction in the UK's greenhouse gas emissions by 2040. And separately, the UK has committed under the Paris Agreement to reduce emissions by 81% against the 1990 baseline by 2035. Now, how this actually is supposed to happen in practice is also envisaged through the Act, because sections 13 and 14 require the government to prepare proposals and policies to enable these budgets to be met, and for those to be reported on to Parliament. Now, at present, there is in fact no lawful plan under the Act setting out those policies and proposals and how the government intends the various sectors of the UK economy to meet them. Now, why is that? Will, if you can skip ahead, please. As you may well be familiar with, the government has had 2 recent attempts to get this right, both of which have been found wanting by the courts. So the first of those attempts was the net zero strategy, which was challenged, and in a judgment handed down in 2022, Mr. Justice Holgate found this to be unlawful. The Secretary of State essentially had not been briefed with a sufficient level of information to enable him to be satisfied that the 6th carbon budget, which was the relevant budget, could be met. So another attempt was made that the government was required by Mr. Justice Holgate to redraft the strategy, and on the 30th of March, the Carbon Budget Delivery Plan was published. Mr. Justice Sheldon, in his judgment of 2024, found that similarly to be unlawful. So among other issues, the court noted that the Secretary of State had irrationally not taken into account the risk that not all of the policies and proposals contained within it would be delivered in full. Now, if you are more interested in the details of those cases and legal challenges to the government policies, I believe that is going to be the subject of a further webinar in this series on the 10th of September. But in any event, so the court ordered the government to produce an updated climate plan by May of this year, the deadline for which has been extended to October. So I think the point is to watch this space for further potential challenges. Thank you, Will. Will, sorry, if we could skip forward, please. Right, thank you. So although the government, and by the UK, therefore, it is subject to this overarching statutory target, there is currently no comprehensive or coherent set of policies and proposals to inform how exactly this is to be achieved. Now, in respect of public and community engagement with these issues, the planning system, which is concerned with how land and natural resources are used and what is permitted to be developed, has proved to be one vehicle for action outside of politics and the ballot box. So within the planning system, that Section 70 of the Town and Country Planning Act provides that in dealing with any planning application, the authority must have regard to the development plan and to any material considerations. The government's National Planning Policy Framework is a material consideration for planning decisions. The most recent version of that framework was published in December 2024, and for the first time refers to the net zero target expressly. So paragraph 161 explains that the planning system should support the transition to net zero by 2050 and take account of all climate impacts, and similarly refers to the need to shape places in ways that contribute to radical reductions in greenhouse gas emissions. Now, more broadly, the courts have recognised that climate change in general is always likely to be a material consideration in planning decisions, given this policy context as well as the wider issues. So you'll see from your screens there that that was a statement made by Mrs. Justice Leven in the 2023 Free Frack Balcombe decision. Now, all of this looks and sounds positive, but on its own, I would suggest that the inclusion of climate and/or the net zero target as a material consideration within the planning and policy framework can lack teeth from the perspective of legal challenges to proposed development. And this is because, in accordance with well-established principles of public law, so long as a decision maker is able to evidence that they have had due regard to a consideration, the weight that they place on it in the overall planning balance is a matter for them. Will, if you could skip forward, please. So there is, however, more pertinently, a detailed framework of statutory provisions and regulations that govern planning consent for potentially environmentally impactful infrastructure projects. And that this framework imposes a suite of duties on developers proposing projects, but also on decision makers, such as local planning authorities, planning inspectors, or indeed the Secretary of State. So I'm not going to set out the framework in full, but just to highlight a few key pieces of legislation and regulations and provisions. So you have the 2017 Environmental Impact Assessment Regulations, which concern projects likely to give rise to significant effects on the environment. So most obviously, those are projects involved with things like fossil fuel extraction, oil refineries and power stations, but can encompass a potentially very broad range of projects in accordance with the provisions of Schedule 2 and Schedule 3. The Planning Act 2008 concerns nationally significant infrastructure projects. Now, what qualifies as such a project is defined by the Act itself, but are projects such as energy infrastructure, transport infrastructure such as roads, water and waste infrastructure. And then the Infrastructure Regulations 2017 effectively imposed the environmental impact assessment requirements on proposed significant infrastructure projects. Thank you all. So to go through some of the suite of duties that these provisions impose, starting with the environmental impact assessment regulations. So the starting point is that no planning permission for development qualifying as environmental impact assessment development can be granted without such an assessment having been conducted. Now, that assessment is in fact described by the regulations as a process consisting of the preparation of an environmental statement, consultation with the public and with certain statutory consultees, for example, Natural England, and then the examination of the environmental information gathered through that process as part of the permitting decision-making. Now, an environmental impact assessment must identify, describe, and assess both the direct and the indirect significant effects of proposed development on the environment, and importantly, on climate. Now, each environmental statement must include sufficient information to enable a reasoned conclusion as to the likely significant effects of a project, and therefore should describe and quantify those effects. Planning decision makers must determine whether a proposed project falls within the assessment regime, which is referred to as screening within the regulations, and indeed the extent of issues to be considered by an assessment referred to as scoping. Thank you, Will. Now, briefly to touch on the Planning Act and the infrastructure regulations in respect of nationally significant infrastructure projects, these require development consent and no other form of planning permission. Now, that consent is granted by the Secretary of State, the relevant Secretary of State. And in order to obtain development consent, developers must submit an application having first complied with the pre-application procedure set out in the provision of the Act and in far more detailed accompanying statutory guidance. Now, that pre-application procedure imposes duties of consultation, both in respect of stakeholders and members of the public, and duties to publicise applications and take account of responses to consultation and publicity exercises. Applications can only be accepted for examination if that pre-application procedure has been complied with. So before you even get to a decision-making process, they won't be considered unless it can be evidence that the requirements have been met by that point. And similarly, if the projects are environmental impact assessment developments, the previous requirements that I took you through will also apply, and that's both at the pre-application stage and during the examination stage of the proposals. So effectively demonstrating that developers and indeed decision makers have not complied with these duties imposed by the statutory and regulatory frameworks has provided the primary mechanism through which successful challenges have been brought to carbon-intensive infrastructure projects over recent years. And this is with that foregrounding that I can hand over to Rowan to take you through some recent examples of where challenges have been brought using those provisions.
Thanks very much, Max. I'm going to be covering 4 recent key climate litigation cases in the UK. I've got about 15 minutes apparently, so I'm going to take them at some pace, but I flag that there is a significant amount of information, material on at least 3 of the cases that we'll cover on Chambers' website. So I should also say it's by no means necessarily a plug for Chambers that we've been involved in 3 of the leading cases that I'm about to cover. Take away from that what you will. Well, on to the first slide, please. The first case I want to talk about is Finch. Now, many of you will have heard about this case already. It's a challenge to the grant in 2019 of a planning permission by Surrey County Council for the extraction of 3.3 million tonnes of oil over about 20 years. The oil was going to be used various combustive processes and commercial purposes off-site after transportation and sale. The key issue was this. The environmental statement, go back please, Will. The environmental statement included information about Scope 1 and Scope 2 emissions, but Scope 3 or downstream emissions have not been included in the environmental statement. The key question in the context of the EIA regulations that Max has just covered was whether it was lawful to restrict the scope of the EIA in this way, and crucially, whether the downstream effect of the combustion of the oil was a likely significant effect of the development for the purposes of the EIA regs. Now, it's an interesting feature of this case that permission was originally refused for the challenge and then refused again an oral renewal hearing, and the claimant had to go to the Court of Appeal for permission. And I flag as well that one of the other cases that I'll cover in a minute, Whitehaven, in that case, permission was also refused in the first instance. And I think this tells us something about how difficult it is to get a message across in climate litigation when systems, ways of thinking are quite entrenched. The law can be as well. But it also tells us, what we can take away from this, is that it can be done, can challenge these systems, and that there are considerable rewards for perseverance. So in Finch, the High Court said that the downstream combustion of the oil was not an effect of the proposal, and then the Court of Appeal on appeal said it could potentially be, but whether it was or it wasn't is essentially a matter of planning judgment. And the Supreme Court rather gave away the game as to what they decided in the first line of their judgment, which is anyone interested in the future of our planet is aware by now of the impact on its climate of burning fossil fuels. So it was relatively clear from that opening statement what they were going to decide. In the decision, the Supreme Court held by a narrow majority of 3-2 that downstream emissions were likely significant effects of the proposal. They should have been assessed within the environmental statement, and the failure to do so was fatal to the permission, which was duly quashed. I think we're probably on to the next slide now, Will, please. Thank you. And I just want to pick out a few key points in the judgment. Now, the first point is that the purpose of the EIA regime is not to ensure that only environmentally safe or beneficial developments are approved. The purpose of the EIA regime is to ensure that the true environmental cost of a proposal is known at the time the planning application is being considered. And of course, public participation in the process is a key factor which provides the legitimacy of decisions, especially when those decisions are affecting the environment. And there's also an educational function in there because advising of the environmental costs of decisions increases public awareness of environmental issues. And it's particularly important in that context for the information in the EIA to be fulsome and accurate. And as Lord Legate pithily remarked in the judgment, you only care about what you know about. That's the first thing. The second thing, allied to that first point, is that the argument that the deficiency in the environmental statement wouldn't have made any difference had to fail, because the EIA legislation is procedural. It's about how a decision is taken. And the public had not been able to comment on the full environmental evaluation of the scheme because those Scope 3 emissions hadn't been taken into account, which is at least one of the key purposes of the EIA regs. So that's the second point, really, is the procedural focus of the EIA regs. And that's picked up again in the Whitehaven case that I'll come on to in a moment. And now the third thing, which is a sort of semi-philosophical question, is whether the downstream emissions were likely significant effects of the proposal. And the court took that exercise in stages, looking first at how one determines whether something is an effect. On that point, the court found that that was essentially a matter of fact and law, and it was therefore something which was in the jurisdiction of the court. Next was the question of whether something's a likely significant effect, and this was held to be a matter of evaluative judgment for the decision maker. But in this particular case, there was no uncertainty about what was going to happen once the oil was extracted. And in short, and I'm quoting from the judgment here, it's an agreed fact that if the project goes ahead, this chain of events and the resulting effects on climate are not merely likely, but inevitable. And further, and you'll see on the slide there, those effects were capable of quantification via meaningful assessment. So you have a process there in which the effects, the downstream emissions, the burning of the combustion of the oil was necessarily going to arise as a result of the extraction of the oil from the project. So the only other key question then was were those likely significant effects of the project itself? And in short, contrary to the decision of the High Court, yes, even though there may have been some separate processes down the line leading to the combustion of the oil, that did not prevent the combustion from being an effect, albeit an indirect one, of the project. And you'll see this in the judgment if you get to it. But the court found that appeals to Kantian metaphysics, which had apparently been applied by the High Court, did not change that fact. So accordingly, the indirect significant effects of downstream combustion failed to be evaluated within the environmental statement. They hadn't been. That was unlawful. And that is Finch in a very, very small nutshell. I want to move on next to the Whitehaven case, just keeping an eye on time. Thanks, Will. Now, first thing about Whitehaven, I want to say is that although we won the challenge, what will obviously concern legal academics for decades to come is that the only ground that I argued before the High Court was unsuccessful. My mum certainly thinks that's particularly outrageous. I'll leave it to you as to what you think. Dealing with the proposal itself changed quite considerably between the application and the eventual inquiry to determine whether permission should be granted or not. It ended up being an application for what we think was probably the world's first claimed net zero mine, with the word claimed doing, I think, quite a lot of the heavy lifting there. Again, a bit like Finch, materially, the downstream emissions had not been factored in as part of the environmental statement exercise. Differently to Finch, the application for permission had relied on a substitution argument that coal produced in the UK would mean that coal would not be produced elsewhere, principally in the US, and that there would be some transportation savings in not having to import the coal, resulting in, it was claimed, no significant net effects arising from the proposal. The Supreme Court's decision in Finch was handed down prior to the hearing, so the key issues in the hearing were how, if at all, does Finch bear on the facts of this case, and did the substitution argument mean that downstream emissions caused no likely significant effect of the proposal, meaning the environmental statement was not deficient. And the outcome, the court found the statement was deficient because it hadn't included downstream emissions within it. And also the reasons provided in respect of substitution were themselves internally inconsistent. And the Secretary of State had failed to grapple with some key evidence as to the likely adverse impact that granting the proposed mine would have on the UK's reputation as a climate leader. In short, South Lake's action on climate change, that's one of the claimants, they won on three of their 4 grounds, and it's not important to cover what happened in the 4th ground. Going into some more detail in the decision, over the page, please, Will. Thanks very much. On the Finch argument, it was common ground the burning of Whitehaven coal was an inevitable consequence of extraction from the mine. It was therefore plain, following Finch, that the greenhouse gas emissions from combustion were likely significant indirect effects of the proposal. They were therefore required to be assessed in the course of the environmental statement, and the Secretary of State was obliged to take that information into account before a permission decision. Now, crucially, it was uncontested that there was sufficient evidence to enable an assessment to be made of those downstream emissions. The calculation could have been done, but it simply wasn't. On the substitution point, the judge summarized the substitution argument, which has been put a number of ways, but he summarized it as follows. Because the extraction of Whitehaven coal would result in an equivalent amount of US coal remaining in the ground, there would be no net increase in greenhouse gas emissions from the new mine, so that the burning of the Whitehaven coal would not be a significant effect. And Mr. Justice Holgate, as he then was, said the consequences of this argument would be absurd. It would mean that as a matter of law, no assessment would need to be made at all in the environmental statement of the greenhouse gas emissions from combustion of the Whitehaven coal or of the substitution of that coal for US coal. And in fact, he says the correct analysis is that both are significant matters. And if substitution of US coal would be a likely effect of the project, both effects have to be assessed. That's what he says about substitution. Very important. I haven't seen any cases raising the substitution argument subsequently. It may be because the court required a relatively high level of information to be provided in respect of such arguments, but we may see them in the future. On public participation, following Finch, the developer needed to produce full information on both the claimed UK emissions and the claimed savings in US emissions, and indeed the claimed transportation savings. But that information had not been provided by the developer. The developer needed to show a very high degree of substitution, not far short of perfect. I'll come back to that in a moment. And if that was shown, it had to show there would be no demand for US coal substituted by that, no other demand for that US coal substituted by the Whitehaven coal. And the underlying technical information in the environmental statement, both during and after the inquiry, hadn't addressed those points. Now, a reason why it was particularly important that claimants had led evidence to show, a reason why that was so important was that the claimants had led evidence to show that even if there were 1% of coal that was not substituted in the manner claimed, this would have had seriously adverse effects in terms of global emissions. Essentially, the equation had to be perfectly balanced, and the consequences of the imbalance were catastrophic in terms of emissions. Now, in that context, the lack of precision as to the measurement of UK versus US emissions, and indeed the claimed transport savings, particularly stood out. Just dealing with the final point, the international impact. At the inquiry, South Lakes, one of the claimants, Friends of the Earth, the other claimant, argued that the UK opening a new coal mine would have had a negative impact on climate change, would diminish the UK's status and role as a climate leader, leading to reduced global ambition in respect of meeting the problem of climate change and increasing global greenhouse gas emissions. Now, SLAC led evidence in particular on this from Professor Sir Robert Watson, whose qualifications are so lengthy I won't read them out, but he was involved in a series of American presidential administrations. He's a very high-level expert in the climate field. His evidence was that permitting the mine would have a negative impact on the UK's climate diplomacy, resulting in reduced ambition and effort from other countries, therefore increasing greenhouse gas emissions worldwide. And this would be the case even if the mine was net zero. In short, the Secretary of State failed to provide adequate reasons as to why that argument was rejected, as to why he was satisfied that opening the mine would not diminish the UK's climate reputation in a way that wouldn't lead to adverse climate impacts generally. So those are the points that I want to make about Whitehaven. The next cases really I want to talk about is Jackdaw and Rosebank. Proposal here was for a development of the Rosebank and Jackdaw oil and gas fields, which are apparently among the largest undeveloped resources of this kind in the UK. The extraction of oil and gas from the sites was of a very significant scale. For example, it was estimated the production of oil from 2026 to 2030 would result in about 7% of the UK's crude oil output. The parties had agreed following Finch that decisions to grant consent for the scheme were unlawful, and as the relevant EIAs did not consider the effect on climate and the combustion of the oil and gas. So the case is really about what happens following that agreement between the parties that the decision to consent being unlawful. As with any judicial review claim, the remedies range from declaratory relief, which is what the developers wanted, unsurprisingly, to a quashing order, which is what the parties sought. And there was also the question of what should happen to the oil fields in the meantime, i.e., should the developers be entitled to continue to develop the fields and to produce oil and gas from them, pending the resolution of the judicial reviews. Now, the court held, in terms of remedy, decisions should be quashed and retaken, this time taking into account the effect of downstream emissions. This consideration involved the balance of private and public interest, i.e., the commercial interest of the developers and the public interest in fighting the effects of climate change. And the court found that the interests of members of the public outweighed the interests of the oil companies, and so they quashed the decisions to grant, although the court suspended the quashing until a fresh decision was reached and found that it would be disproportionate to require work on the projects to cease completely with immediate effect. The court did find, however, that no oil or gas could be extracted from the sites during the suspension period, and that further development would take place at the developer's risk. In short, they can keep developing the fields, i.e. setting out the infrastructure for potential extraction, in the hope that when the decision is taken, permission is granted, but there can be no extraction of oil in the meantime. Will, I think we can just skip over to Boswell, please. I don't want to eat in too much into Lois's time, so I'm just going to skip over that. Great. Yeah. So the Boswell case, this is a project. This was a grant of consent for 3 separate road improvement schemes to the A47 trunk road in Norwich, which was proposed by National Highways. Now, the issue was whether the Secretary of State had, in the 3 letters consenting the schemes, lawfully discharged the obligation within the 2017 infrastructure EIA regulations to examine and assess the cumulative future greenhouse gas emissions generated by vehicles using the roads once they were operational. A few words on the EIA which had been carried out. It had weighed the greenhouse gases expected to be generated, including emissions from vehicles once roads were operational. The methodology took into account the scheme in isolation, but also in combination with the wider road network, assuming in each of the schemes, the assessment in each of the schemes, that the other 2 schemes would be implemented, and it estimated the increasing emissions and then compared them with the UK carbon budget. And the net change was presented as a percentage of the carbon budget. Now, somewhat unsurprisingly, the percentage net change was very small when compared to the entire carbon budget. And the court noted, just over the page, please, Will. The court noted that the National Policy Statement for Networks 2014 recognised that an increase in carbon emissions is not necessarily a reason for refusal unless the increase is so significant as to impact the delivery of the UK's carbon budgets. The Secretary of State in that case had acknowledged in the decision that the proposed development would result in an increase in carbon emissions, but found that the increase would not be sufficiently significant to have a material impact on the government's ability to meet its reduction targets. And the quantification of the projected emissions and the methodology comparing the projected emissions had not been challenged. The scheme, or the challenge that was proposed, was premised on the basis that the combined projected emissions from the schemes and the related projects had not been compared to the budgets. Now, the Court of Appeal dismissed the claim, finding that the Secretary of State had before him and considered the forecast emission from each scheme and the other existing roads and planned projects, as well as information from impact on the wider road network. The schemes in the Court of Appeal's decision had not been viewed in isolation, and each had been placed in a wider local context, and the cumulative future emissions likely to be generated in that context were compared against the national carbon budgets. Decisions themselves showed the Secretary of State had considered the likely future emissions from the schemes calculated in wider local context and found that these were not significant compared, as I say, to the wider carbon budget. And it was appropriate, the court found, to compare these emissions to the national carbon budget because, of course, carbon emissions have no geographical boundary. They're experienced uniformly across the country and indeed across the globe. So that is the Boswell case taken at some pace. And with that, I've got through my 4 cases, and I'm going to hand over to Lois.
Thank you very much, Rowan. So, and thank you for Max too for setting out the context. Now we're going to take a look ahead to what we might see over the next few months and years. And so if we can pop onto the next slide, you'll see that I've picked out 3 different themes here to take a bit of a whistle-stop tour through. So the first, touched on fairly briefly, will be some of the more traditional types of planning and policy, judicial and statutory reviews that we're likely to see in the near future or that are ongoing, making their way through the courts at the moment, and especially focusing on aviation expansion challenges, because we're looking like we're going to have a big year or so for those. Next, I'm going to think about some of private law claims and different types of private law claims, and look abroad to claims that have succeeded in other jurisdictions or succeeded in part, and how those might be applicable in the UK context. And finally, take a look at some of the human rights-based challenges that have made their way through the European Court of Human Rights, and have a bit of a think about the potential impact of some key advisory opinions that have come out of international courts and tribunals over the last 18 months. So if we can pop on to the first, in fact, we can go another slide and head to, yes, aviation expansion. So in terms of traditional judicial reviews, one really big story over the next year is going to be aviation expansion. We know that this is a real priority for the government as part of its kind of broader growth agenda. We know that aviation, more than almost any other sector, is virtually impossible to decarbonise, and that it's an increasing share of the UK's overall emissions, and that makes for a really thorny legal battleground. So currently, there's a challenge to the decision by the Secretary of State to grant permission for Luton Airport to expand in a DCO for that project, and the local group bringing that challenge, Litigation, were granted permission fairly recently on all 5 of their grounds of challenge. That's due for a substantive hearing in the autumn, and they've got, amongst other things, a sort of a Finch ground in that case, because it relates in part to the failure of the developer to provide information on downstream emissions from inbound flights to the expanded airport. And they've also got a ground that relates to this second bullet point, which is the outstanding appeal in a legal challenge to the Jet Zero strategy, which is the government's overarching strategy for decarbonising aviation. That strategy relies very heavily on the development of new technologies and sustainable aviation fuels, and the legal challenge focused on consultation, pre-strategy consultation, on the treatment of different alternative options, and in particular on the fact that demand management, i.e. trying to stop more people from flying rather than changing the fuels used in planes, wasn't seriously considered as part of the process of developing the strategy. So that's gone to the Court of Appeal for a decision on permission, and we'll find out soon what the latest is going to be with that. There's also very likely to be, I would say, a challenge to any decision on Gatwick Airport, which is due again in the autumn. Originally, that decision was due in February by the Secretary of State. However, the examining authority that dealt with the examination of the DCO application recommended refusal on the basis of unmitigated environmental impacts on both transport and noise, but also on climate. They did, however, state that there was an alternative version of the DCO, an alternative option with different requirements to mitigate noise and transport issues, and that on that basis they could recommend permission be granted. The Secretary of State has indicated that she is minded to grant permission. The decision was delayed for 6 months to enable her to make that final decision. But if permission is granted on the basis of an alternative version dealing with noise and transport issues, and yet those climate impacts remain unmitigated because they are unmitigable, it seems very likely that we'll see another challenge there. And then, of course, at some point in the not too distant future, we're expecting the third runway at Heathrow come back again. That's been in a bit of a lull for the last 5 years or so, but we're expecting potentially applications to go in around that in the not too distant future. So aviation likely to be a really big story in domestic traditional public law challenges. But moving on to other types of challenge, and if we could head to, yes, private law claims. So one type of private law claim that's been attempted in this jurisdiction, but without any real success so far, is shareholder litigation and derivative actions. And if we could go to the next slide, you'll see that one crucial bit of litigation here was the Client Earth and Shell litigation. This was back in 2023, and it built on a case, a Dutch case, Milieu Defensie and the Royal Dutch Shell Company, and that was a very famous judgment where a Dutch court ordered Shell to reduce its global emissions by 45% by 2030, based on a standard of care found in the Dutch Civil Code. Now, that judgment has since been successfully appealed, at least in part, but it inspired in the UK context, if we can head over the page, a litigation brought by Client Earth as the owner of 27 shares in Shell, a derivative action that they brought against the board of directors, essentially arguing that the board of directors, in adopting their energy transition strategy, hadn't adequately put in place long-term measures to secure the financial future of the company, and that they'd breached various sections and various provisions and duties under the Companies Act 2006, and in particular, in fact, because they hadn't put in place proper strategies to deal with their Scope 3 downstream emissions, which are, of course, the vast bulk of their emissions. So Client Earth attempted to bring this case. It was dismissed after an oral permission hearing, so it didn't proceed to a full hearing, and that was on the basis of a few different points made by the judge in that case. One was that Client Earth was felt not to be sort of sufficiently expert, and the form of its evidence was considered not to be sufficient to be expert evidence to provide proper evidence of the director's actual failure to manage climate risk, and the evidence wasn't in the proper form. There was also an alleged breach of the Dutch order, and the court found that there was no duty on directors under English law to comply with a foreign order, so that part of the challenge failed. And finally, and perhaps most interestingly, the court found that the claim at least appeared not to have been brought in good faith, i.e. Client Earth as the owners of a small number of shares in Shell, and perhaps unspoken as a large environmental legal NGO, were seen to be bringing this claim not really because they were concerned shareholders of Shell, but for broader political reasons. So it was found that the claim wasn't brought in good faith. Now, there's a very interesting article that I would commend to all of you, written by Lord Carnwath for the Grantham Institute, where he's a visiting professor, in which he argues that this case should have been allowed to proceed to a full hearing, and that it would have been beneficial for the purposes of the development of the law in this area for the issues around duties under the Companies Act in respect of climate change to be fully ventilated and litigated. It's a very interesting piece and well worth a read. But will we see more of these types of cases? Well, possibly. Moving on, we also have seen in other jurisdictions the beginnings of cautious claims around climate being used in quite interesting ways. And if we can again flip over the page, one really crucial and recent case here is that of Lois and RWE, which is a German case, and it was brought by a Peruvian farmer whose farm was near a glacial lake. The glacier is melting, the lake is rising. There's a real danger, the claimant said, that the lake is going to burst its banks, flood his land, and essentially make his land unfarmable. And this case was dismissed on the facts because the court found that actually he hadn't provided sufficient evidence of the specific risk of the lake bursting its banks and the risk to his property from that happening. But crucially, this case did confirm the principle that companies and parent companies can be liable for climate harms caused directly or by their subsidiaries. And the court considered both climate attribution science, i.e. what portion of climate damage can be attributed to what sources, and also took quite a Finch-like approach to causation of climate harm. And if we can go over the page, you will see that, so they acknowledge that climate attribution science can provide a basis for a claim of this type in tort for environmental damage. And they took a fairly traditional approach to causation in essence, where they looked at foreseeability, as we'd call it in English tort law, and then the relative significance of different organizations or states' contributions to harm in multi-causal scenarios, and the attribution of that harm. And on the facts, the company in this case, the energy company, was found to be the direct tortfeasor, even though its plants were operated by subsidiaries. So this reflects a kind of broader uptick we've seen in the last few years of environmental claims more broadly, mostly pollution claims rather than climate, specifically being brought against parent companies in the jurisdiction in which they're domiciled, rather than in the claimant's own jurisdiction where the subsidiary is operating. And it will be fascinating, I think, to see over the next months and years the extent to which the approach of the court in Luya, the German court in Luya, is adopted in other jurisdictions, and particularly in the UK, if we get any more tortious climate claims being brought in this jurisdiction. And then finally, if we can head to rights-based challenges and the advisory opinions, as I've rather grandly referred to them here. So next slide, please, Will. And I'm not going to touch on these in much detail because I am conscious of time, but there have been a couple of really quite fascinating human rights-based climate challenges in the European Court of Human Rights over recent-ish years. There was a case brought by a group of Portuguese young people, Duarte Agostinho in Portugal, and there was another one brought by a former mayor of a town in France, Carême in France. And in both of these cases, the claims were in essence arguing breaches of Articles 2 and 8 of the European Convention on Human Rights in the context of climate change and the failure by states to put in place adequate policies in respect of climate change. Now, both of those two cases I just referred to were ruled inadmissible for lack of standing or for various jurisdictional issues, or in the case of Agostinho in Portugal, for a failure to exhaust domestic remedies before applying to the European Court. So the substantive human rights issues weren't actually argued in those cases in the end, or they weren't featured in the judgments. But one case which did succeed in part was the Verein Klima Seniorinnen in Switzerland case, otherwise known as the Swiss Grannies case. And that succeeded in part. The individual elderly Swiss women who attempted to bring the claims as individuals were not found to have standing, but their association that they had formed was, and it was found that there was an infringement of their Article 8 rights, and specifically that, and I see that unfortunately that text has gone behind the picture there, but specifically that states, including Switzerland, have common responsibility for addressing climate change and for putting in place specific measures to address climate change, whether or not the emissions being generated are within their jurisdiction or not. So it confirmed that rights-based challenges to state inaction on climate could cross transnational boundaries, in essence, that individual states could be held liable for climate harms, even though climate change is, of course, a global problem and the effects are felt globally. And essentially, the findings of the court, or the majority of the court, there's a defense from the UK judge on the court, but the findings of the majority are reflected to some extent in some of these advisory opinions that we've also had recently. So moving to the next slide, please, Will. There's been 3 of these over the last 18 months or so. The first was the International Tribunal of the Law of the Sea, which was asked by Vanuatu to provide an opinion on whether or not essentially climate change constituted marine pollution under the UN Convention on the Law of the Sea, because states have obliged themselves under that convention to take measures to avoid marine pollution that affects transnational waters. And one of the questions for the tribunal in that case was, or in that advisory opinion, was whether or not climate pollution was pollution of the marine environment under that convention. The tribunal found that it was, and also that traditional principles of customary international law did apply to these transnational climate harms. We then had the Inter-American Court of Human Rights advisory opinion on the 3rd of July this year, which affirmed an overarching human right to a stable climate, fairly sweeping and important statement there, and also set out at some length the obligations on states to meet their various obligations under the UN Framework Convention on Climate Change and the Paris Agreement, and the temperature goals under the Paris Agreement. And those are all set out in the paragraphs of the judgment cited on this slide. And finally, also in July, we had the International Court of Justice, and there's going to be another Cornerstone Climate webinar dealing with this in more detail, so I won't touch on it very much, but it crucially again stated that states have an obligation to adopt concrete measures to achieve their goals under the UNFCCC and the Paris Agreement, and that failure to adopt these concrete measures, not just to set targets, but to actually adopt measures to meet them, could constitute an internationally wrongful act that might be attributable to that state. Now, these opinions are, of course, only advisory, but they are certainly very persuasive, and it will be very interesting to see the extent to which any of the findings of the courts in these various contexts filter down into domestic climate change litigation, whether we start to see them relied upon in domestic cases, and whether those would have to be specifically sort of human rights-based cases, or if we might start to see them cropping up in other more traditional public law contexts and judicial review challenges. So turning then to my summary slide, which I think is next. Yes, key takeaways. What should we look to see? Well, first, traditional planning and policy judicial reviews are not going away. They're going to be plenty more over the coming years, I'm sure, although do watch this space for potential restrictions in both the planning and infrastructure bill that's going through Parliament at the moment, and this sort of much trailed future bill that Rachel Reeves has been in the news as wanting, around restricting legal challenges to major infrastructure projects. It remains to be seen whether those will make it through Parliament in their sort of current or future forms, and what effect they might have. But certainly there is at the very least likely to be more attempts to challenge these big infrastructure projects if they're high emitting projects. We are also very likely, I think, to see the attempt made at more claims in tort, building on LUIA and building on some of those other environmental class actions that I touched upon earlier. The jury's still out, I think, on shareholder actions, perhaps with, I've put here, perhaps with the right claimant. And I think perhaps if you had an organization or an individual who was a major shareholder in a high emitting company, and perhaps with a more demonstrable professional, ongoing professional or investment relationship with that company, who also was concerned about stranded assets or something of that description, maybe a claim brought by that kind of claimant might be seen to be brought in good faith and could get over that hurdle and proceed to a full hearing where the Client Earth case wasn't able to. And finally, these rights-based claims will almost certainly continue, and watch this space for how the advisory opinions might filter through. And next slide, please, Will. Just a plug for some of the other webinars coming up in our Cornerstone Climate series. So next week on the 10th of September, some of our fantastic colleagues will be looking at the UK's progress towards net zero and picking up on some of what Max talked about at the beginning of this session. And then we've got a very exciting joint webinar with Opportunity Green on the 15th of September on that International Court of Justice advisory opinion and what its broader implications will be. And that's with speakers from Opportunity Green and the Centre for International Environmental Law. So please do sign up for those. The recording of a previous webinar that we did on the judgment in Luya will also be being uploaded to our YouTube channel. So please take a look at that as well if you're interested in the Luya claim. Lots more in this space. Now, I can't see that there are currently any questions in the Q&A. So the opportunity to ask a question is there, going once, going twice. But if nobody has any questions at this stage, then I will allow you all to head for your lunch 5 minutes early. But thank you so much for joining us. Please do drop us a line if you do have questions. The email address is on screen. And thank you to Max and Rowan for their brilliant contributions to this webinar. Have a lovely rest of your Wednesday, everybody. Thank you.